The Factories Act 1948, Act No. 63 of 1948, Chapter 6, Working Hours of Adults. 60. Restriction on double employment. No adult worker shall be required or allowed to work in any factory on any day on which he has already been working in any other factory, save in such circumstances as may be prescribed. 61. Notice of periods of work for adults. 1. There shall be displayed and correctly maintained in every factory in accordance with the provisions of subsection 2 of section 108 a notice of periods of work for adults, showing clearly for every day the periods during which adult workers may be required to work. 2. The periods shown in the notice required by subsection 1 shall be fixed beforehand in accordance with the following provisions of this section, and shall be such that workers working for those periods would not be working in contravention of any of the provisions of sections 51, 52, 54, 255, 56 and 58. 3. Where all the adult workers in a factory are required to work during the same periods, the manager of the factory shall fix those periods for such workers generally. 4. Where all the adult workers in a factory are not required to work during the same periods, the manager of the factory shall classify them into groups according to the nature of their work, indicating the number of workers in each group. 5. For each group which is not required to work on a system of shifts, the manager of the factory shall fix the periods during which the group may be required to work. 6. Where any group is required to work on a system of shifts and the relays are not to be subject to predetermined periodical changes of shifts, the manager of the factory shall fix the periods during which each relay of the group may be required to work. 7. Where any group is to work on a system of shifts and the relays are to be subject to predetermined periodical changes of shifts, the manager of the factory shall draw up a scheme of shifts where under the periods during which any relay of the group may be required to work and the relay which will be working at any time of the day shall be known for any day. 8. The state government may prescribe forms of the notice required by subsection 1, and the manner in which it shall be maintained. 9. In the case of a factory beginning work after the commencement of this act, a copy of the notice referred to in subsection 1 shall be sent in duplicate to the inspector before the day on which work is begun in the factory. 10. Any proposed change in the system of work in any factory which will necessitate a change in the notice referred to in subsection 1 shall be notified to the inspector in duplicate before the change is made, and except with the previous sanction of the inspector, no such change shall be made until 1 week has elapsed since the last change. 62. Register of adult workers. 1. The manager of every factory shall maintain a register of adult workers, to be available to the inspector at all times during working hours, or when any work is being carried on in the factory, showing a. The name of each adult worker in the factory, b. The nature of his work, c. The group, if any, in which he is included, d. Where his group works on shifts, the relay to which he is allotted, e. Such other particulars as may be prescribed. Provided that, if the inspector is of opinion that any muster roll or register maintained as part of the routine of a factory gives in respect of any or all the workers in the factory the particulars required under this section, he may, by order in writing, direct that such muster roll or register shall to the corresponding extent be maintained in place of, and be treated as the register of adult workers in that factory. 1a. No adult worker shall be required or allowed to work in any factory unless his name and other particulars have been entered in the register of adult workers. 2. The state government may prescribe the form of the register of adult workers, the manner in which it shall be maintained and the period for which it shall be preserved. 63. Hours of work to correspond with notice under section 61 and register under section 62. No adult worker shall be required or allowed to work in any factory otherwise than in accordance with the notice of periods of work for adults displayed in the factory and the entries made beforehand against his name in the register of adult workers of the factory. 64. Power to make exempting rules. 1. The state government may make rules defining the persons who hold positions of supervision or management or are employed in a confidential position in a factory, or empowering the chief inspector to declare any person, other than a person defined by such rules, as a person holding position of supervision or management or employed in a confidential position in a factory if, in the opinion of the chief inspector, such person holds such position or is so employed, and the provisions of this chapter. other than the provisions of Clause B of subsection 1 of Section 66 and of the proviso to that subsection, shall not apply to any person so defined or declared, provided that any person so defined or declared shall, where the ordinary rate of wages of such person does not exceed the wage limit specified in subsection 6 of Section 1 of the Payment of Wages Act 1936, 4 of 1936, as amended from time to time, be entitled to extra wages in respect of overtime work under Section 59. 2. The state government may make rules in respect of adult workers in factories providing for the exemption to such extent and subject to such conditions as may be prescribed. A. Of workers engaged on urgent repairs, from the provisions of sections 51, 52, 54, 55 and 56. B. Of workers engaged in work in the nature of preparatory or complementary work which must necessarily be carried on outside the limits laid down for the general working of the factory, from the provisions of sections 51, 54, 55 and 56. C. Of workers engaged in work which is necessarily so intermittent that the intervals during which they do not work while on duty ordinarily amount to more than the intervals for rest required by or under Section 55, from the provisions of Sections 51, 54, 55 and 56. D. Of workers engaged in any work which for technical reasons must be carried on continuously, one from the provisions of Sections 51, 52, 54, 55 and 56. E. Of workers engaged in making or supplying articles of prime necessity which must be made or supplied every day, from the provisions of Section 51 and Section 52. F. Of workers engaged in a manufacturing process which cannot be carried on except during fixed seasons, from the provisions of Section 51, Section 52 and Section 54. G. Of workers engaged in a manufacturing process which cannot be carried on except at times dependent on the irregular action of natural forces, from the provisions of Sections 52 and 55. H. Of workers engaged in engine rooms or boiler houses or in attending to power plant or transmission machinery, from the provisions of Section 51 and Section 52. I. Of workers engaged in the printing of newspapers, who are held up on account of the breakdown of machinery, from the provisions of Sections 51, 54 and 56. Explanation. In this clause the expression newspapers has the meaning assigned to it in the Press and Registration of Books Act 1867, 25 of 1867. J. Of workers engaged in the loading or unloading of railway wagons, or lorries or truck, from the provisions of Sections 51, 52, 54, 55 and 56. K. Of workers engaged in any work, which is notified by the state government in the official gazette as a work of national importance, from the provisions of Section 51, Section 52, Section 54, Section 55 and Section 56. 3. Rules made under subsection 2. Providing for any exemption may also provide for any consequential exemption from the provisions of Section 61 which the state government may deem to be expedient, subject to such conditions as it may prescribe. 4. In making rules under this section, the state government shall not exceed, except in respect of exemption under Clause A of subsection 2, the following limits of work inclusive of overtime. I. The total number of hours of work in any day shall not exceed 10. E. The spread over, inclusive of intervals for rest, shall not exceed 12 hours in any one day, provided that the state government may, in respect of any or all of the categories of workers referred to in Clause D of subsection 2, make rules prescribing the circumstances in which, and the conditions subject to which, the restrictions imposed by Clause I and Clause E shall not apply in order to enable a shift worker to work the whole or part of a subsequent shift in the absence of a worker who has failed to report for duty. I.e., the total number of hours of work in a week, including overtime, shall not exceed 60. If the total number of hours of overtime shall not exceed 50 for any one quarter. Explanation. Quarter means a period of 3 consecutive months beginning on the 1st of January, the 1st of April, the 1st of July or the 1st of October. 5. Rules made under this section shall remain in force for not more than 5 years.